Equality before the law is a cornerstone of modern democratic societies and one of the most fundamental principles of justice. It holds that every individual, regardless of social status, wealth, race, religion, gender, or political affiliation, is entitled to the same treatment under the legal system. This principle embodies the idea that the law should act as an impartial framework that protects individual rights and regulates societal conduct without favoritism or discrimination. Rooted in both ancient traditions and Enlightenment thought, equality before the law has become a universal standard, enshrined in constitutions, human rights charters, and international treaties. The principle is not merely abstract, but has real-world implications. It shapes how states construct their legal frameworks, how judges interpret the law, and how citizens experience justice. Yet, despite its universal recognition, the practical implementation of equality before the law has been uneven and challenged by systemic inequalities, economic disparities, and historical injustices. Historical development of the principle. The concept of equality before the law has deep historical roots. Ancient legal systems, such as the Code of Hammurabi, c. 1754 BCE, contained early attempts to establish uniform rules, though these codes often reflected hierarchical social orders. In classical Athens, the idea of isonomia, equal law for all citizens, was central to democratic governance, though restricted to free male citizens and excluding women, slaves, and foreigners. Roman law also contributed significantly by developing the principle of equitas, equity, and applying consistent rules across its vast empire. This laid the foundation for later European legal traditions. During the Enlightenment, thinkers such as John Locke, Montesquieu, and Jean-Jacques Rousseau advanced the idea that laws should apply equally to all. The French Declaration of the Rights of Man and of the Citizen, 1789, explicitly stated that all citizens, being equal in the eyes of the law, are equally admissible to all public dignities, places, and employments. Similarly, the American Declaration of Independence, 1776, proclaimed the equality of men, though it took centuries for these ideals to extend beyond white male property owners. Equality before the law in modern legal systems. In contemporary societies, equality before the law is a constitutional guarantee. Most modern states explicitly enshrine this principle in their founding documents. For example, United States, the 14th Amendment guarantees equal protection of the laws to all persons. United Kingdom, the principle was reinforced by the rule of law, articulated by jurist A.V. Dicey, who emphasized that no one is above the law, including the government itself. European Union, Article 20 of the Charter of Fundamental Rights affirms that everyone is equal before the law. United Nations. The Universal Declaration of Human Rights, 1948, in Article 7, declares that all are equal before the law and are entitled without any discrimination to equal protection of the law. These legal formulations reflect the aspiration that justice should not privilege certain groups. Courts, legislatures, and international bodies use equality before the law as a guiding norm when assessing issues like discrimination, human rights violations, and access to justice. Dimensions of equality before the law. 1. Formal equality. Formal equality means that laws must apply in the same way to all individuals. A government cannot legally exempt a privileged group from taxation or grant immunity to powerful actors. This aspect reflects the rule of law principle. 2. Substantive equality. Substantive equality recognizes that merely treating everyone the same may not be sufficient, because structural inequalities often create disadvantages for marginalized groups. For example, while men and women may have equal rights to education and law, social or cultural barriers may prevent women from accessing these opportunities. Substantive equality, therefore, requires corrective measures such as affirmative action or anti-discrimination policies. 3. Equality of access to justice. Equality before the law requires that all individuals have equal access to courts and legal remedies. However, economic disparities often mean that wealthier individuals can afford better legal representation, while poorer individuals face barriers to justice. Legal aid and public defender systems are thus essential to realize this principle in practice. 4. Equality of accountability. Equality before the law demands that no person, regardless of status, is above the law. Heads of state, government officials, and influential corporations must be held accountable for their actions under the same legal standards that apply to ordinary citizens. Challenges to equality before the law. Despite being a universal legal norm, many barriers prevent its full realization. Systemic discrimination, racial, ethnic, religious, and gender discrimination often result in unequal treatment within legal systems. For instance, minority communities in many countries experience higher rates of policing, prosecution, and incarceration. Economic inequality. Wealth plays a significant role in legal outcomes. Access to high-quality lawyers, bail money, and resources often determines how effectively individuals can defend their rights. Political power. In some societies, political elites manipulate the law to shield themselves from accountability. Selective prosecution and corruption undermine the impartiality of justice. Historical legacies. Colonialism, slavery, and apartheid have left structural inequalities that persist even after legal reforms, affecting how laws are applied in practice. Cultural and gender biases, deeply embedded social attitudes often influence judicial decisions and the functioning of the legal system, perpetuating inequality despite formal guarantees. Case studies. 1. Brown v. Board of Education, 1954, United States. This landmark decision ended racial segregation in public schools, affirming that separate but equal facilities were inherently unequal. It was a turning point in the struggle for civil rights and demonstrated the role of equality before the law in challenging systemic injustice. 2. South Africa and the end of apartheid. The 1996 South African Constitution enshrined equality before the law as a reaction against decades of racial segregation. It included strong protections for equality and non-discrimination, setting a model for constitutional design worldwide. 3. European Court of Human Rights, ECHR. The ECHR consistently applied equality principles to cases involving minority rights, gender discrimination, and access to justice. Decisions like DH and Others v. the Czech Republic, 2007, which found racial discrimination in the placement of Roma children in special schools, illustrate how international courts enforce equality before the law. Theoretical foundations. Philosophical perspectives shed light on why equality before the law is essential. Natural law theory. Thinkers like Thomas Aquinas argued that laws derive legitimacy from moral principles, and since all humans share natural rights, laws must treat them equally. Liberalism. John Locke and John Stuart Mill emphasized that equal legal rights safeguard liberty and prevent tyranny. Critical legal studies. This perspective critiques the claim of neutrality, arguing that the law often reinforces social hierarchies under the guise of equality. Rawls' theory of justice. John Rawls argued that principles of justice should be chosen behind a veil of ignorance, ensuring that laws are designed without knowledge of one's own social position, thereby guaranteeing fairness. Equality before the law and human rights. Equality before the law is not just a legal doctrine. It is integral to the human rights framework. Human dignity cannot be protected if laws are applied unequally. International organizations, such as the United Nations and the International Criminal Court, rely on this principle to prosecute crimes against humanity, genocide, and war crimes. Without equal accountability, justice would be selective and arbitrary. Equality before the law is more than a legal principle. It is the bedrock of justice and democracy. From ancient legal codes to modern constitutions and then international human rights instruments, societies have recognized the necessity of impartial legal systems. However, the journey from formal declarations to substantive reality remains incomplete. Economic disparities, systemic discrimination, political corruption, and cultural biases still obstruct true equality before the law. The task of modern societies is not only to preserve the principle in written law, but also to enforce it through accessible justice systems, independent judiciaries, and proactive policies aimed at dismantling structural inequality. Only then can equality before the law transform from an aspirational ideal into a lived reality for all people. Sources. Dicey, A.V., 1959. Introduction to the Study of the Law of the Constitution, Macmillan. 2. Rawls, J., 1971. A Theory of Justice, Harvard University Press. 3. United Nations, 1948. Universal Declaration of Human Rights. 4. European Union, 2000. Charter of Fundamental Rights of the European Union. 5. Brown v. Board of Education 347 U.S. 483 1954. 6. South African Constitution 1996. 7. DH and others v. the Czech Republic European Court of Human Rights. Application No. 5732500 2007. 8. Locke J. 1690. Two Treatises of Government.